What's up, everyone? This is your host, Ghost, coming to you live with another wonderful video. How is everyone doing today? Sorry I'm a little late today. Had a long evening. It's my bad. Slow today, but it's all good. I'm on roughly time. Um, let's see. Make sure you follow me on X at official. Or sorry, fuck man, I am so goddamn tired. So before I get into that housekeeping stuff, hold on, be right back. All right, my bad. I had to clean up something. So we're going to talk about Trump trial day 20. It's actually technically the last day because everyone ends up resting today. So there's nothing much to really. Um, there's not going to be any trial after this. I think they've rested for the week, and they'll come back Tuesday, and then they will do. They'll do the closing arguments, and the jury will begin deliberation. Um, so Thursday and Friday, I'll do some reaction stuff. I'm going to react to um, I don't know what to call it. Basically, a panel, not a panel, a debate, I guess, with Pearly Things, Laura Chen, and Isabella Moody, and Andrew Wilson's wife, Rachel Wilson. I think we're saying what her name was. So I'll look at that, and I'll do a reaction to that. So I'll do that tomorrow. Friday, I'll do a regular reaction stream, and then starting Monday, um, will basically be going back to normal how it used to be. And then Tuesday, Monday, Tuesday will be normal, what we normally do. Whatever news I find interesting, I'll talk about it. And then Wednesday, I will look at the summation and the closing arguments and everything, and we'll see if we get um, a verdict. When we'll get a verdict. I mean, we could get a verdict Tuesday. There's really not much evidence here, and there's not much evidence to really convict Trump. All he really got for proof of evidence is Michael Conan's word, and Conan's word is shit. And also, even after all that, even if they gave them a guilty verdict, the judge could still decide to dismiss the charges anyways, because he has reserved that right to dismiss the charges. And I think he did that because he also agrees that the prosecution doesn't, because he could have just said, no, I'm not going to dismiss this case. But he reserved the right. He reserved it to wait till the jury's decision. So I think that's telling. I think he's saying that, like, I also don't think the prosecution has um what's what I'm looking for. I don't think they've proven their case at all either. But I don't want the backlash in the media, so I'm gonna hope that the jury will find Trump not guilty, as he should be, and then I don't have to make the decision. But if it turns out not guilty, I'm going to have to make the decision, because there's no way a reasonable jury could find Trump guilty based on the evidence alone. Again, the only evidence they have that any of the documents were false was Conan. That's all they got. It was Conan's word saying it was false. Okay, that's all the evidence the prosecution has presented. They have presented the actual documents, and and uh, and yeah. So yeah, they also haven't really put up the crime, because the portion of the business falsifying business documents thing is you have to intend to. You're doing it with the intent of concealing or committing a crime. It's part of it, and all they really did was stuff. I don't even think it's legal. I don't think it's illegal to because no one's been charged with it. Period. Uh, but all it's all they've brought up is some sort of co-conspiracy of election interference by catching and killing bad stories for good story and propping up good stories. But I don't think Pecker's been indicted for that. I don't think Weiselberg has been indicted for that. So, I mean, is that really a crime to pay for stories and not run them? It's not a crime. Um, so I don't know. But anyways, we'll get into it. And I'll share my final thoughts once we're all done. Um, let's see. After that, we got um. No, that's it. All right. So now we'll do some housekeeping on my end. Sorry, I'm just waking up. Follow me on X at officialwghost. That's the best way to find out when I go live and what I am up to. Um, you can also see me live as well if you're gonna hop on X. If you can follow me on Rumble, rumble.com/withghost. That is also a good place to check me out. Let's see. Hold on. Sorry, fucking with stuff and messing shit up. Okay. So yeah, I said Rumble. YouTube.com/@withghost is YouTube. Twitch.tv/official with Ghost is obviously Twitch. My gaming channels for Rumble is Gaming with Ghost, and YouTube is @official Gaming with Ghost. So those are your various options to watch me do stuff. I haven't yet to be playing games live for a bit. Been busy taking care of the sick wife and the kids and everything. So hopefully we'll be back to playing some stuff here in a bit. But who knows? All right. So I guess we shall get into it. Yeah. So let's get into it. Let's get physical. All right. So, oh shit, I probably should hit presentation, huh? I'm sure you guys will want to watch this. All right. So Trump is in courtroom. Court's in session. Merchant called for the defense witness Robert Costello. Robert Costello has entered the courtroom. Good morning, Mr. Costello. Welcome back. I remind you that you're still under oath, Merchant said. Costello apparently spoke to Merchant, but it was off mic. And remember, Merchant and Costello got into it a bit. Got a little heated. They actually ended up having to clear the courtroom so Merchant could give Costello a dressing down. So, jury entered the courtroom. Let's see, cross-examination is back underway. Hoffinger has resumed her cross-examination of Costello. Hoffinger begins by asking Costello about the fact that Conan ultimately hired another firm to represent him, not Costello's firm. The jury is being shown an email dated August 8th, 2018. Conan emailed Costello and Citron stating, "Gentlemen, please cease contact me as you do not and have never represented me in this matter." And, in this or any other matter, the email continues. Your interest and offers to become part of the team and to serve as a contact was subject to existing counsel Guy Petrillo CC'd approval, which was denied. Costello asks, or Javier asks Costello. So, I mean, all right. So the email is, "Hey, I don't want to represent. I don't want you representing me." Cool, and doesn't really refute Costello's claim that he didn't really care whether he represented him or not, unless there's an email saying, "You asshole, how dare you do this to me? I could have made millions or some shit like that." Let's see. Officer asked Costello whether he discussed with Conan how connected he was to Rudy Giuliani at their first meeting at the Regency Hotel. That's not true, Costello says. Costello says they did not say that at the first meeting, but mentioned Giuliani later. Hoffinger confirms that Costello that Giuliani was at his wedding. Yeah, so Conan made a big thing saying that Costello's like, I'm connected to Giuliani, I can get you in, you can we can have a back channel, blah blah blah. Again, this is all Conan's word against it's against Costello, because he's trying to attempt that show that Trump was pressuring him via Costello. The other point, this is a he said. And you got to figure out who you're going to believe. You're going to believe the known liar, or the guy who may have an attitude problem, but so far hasn't been proven to be a known liar. Hoffinger shows the jury an email from Robert Costello to Conan on April 19th, 2018, indicating that Rudy Giuliani was joining Trump's team. I'm sure you saw the news that Rudy is joining the Trump legal team. I told you my relationship with Rudy could be very useful for you, Costello emailed Conan. Hoffinger went on to show Costello another email he sent to Jeff Citron on April 19, 2018. All the more reason for Conan to hire me because of my connection to Giuliani, which I mentioned to him in our meeting. That was your email, correct? Hoffinger asked. Correct, Costello says. Hoffinger has asked Costello if he was pushing Conan to retain him because he could provide a back channel to Trump. Costello again denied. Oh, yeah, there's no proof of that. He was pushing because he had the back channel. He could have just mentioned it for the added benefits. Like, here's an added benefit if you hire me. Hoffinger then showed Costello in the email and the jury an email he sent to Conan mentioning a back channel. This was your email to Conan. Yes, Costello says. This email speaks for itself, right, sir? Hoffinger says, no, not quite. There are circumstances about the email, which I would be delighted to tell you, Costello says. That's all right. Let's move on to the next one. Ooh, that's not a good look, Hoffinger. That's not a good look. It looks like you're trying to hide something from the jury. I'm sure the defense will, when they do their rebuttal, because again, remember, it's defense's case now, so they do the direct, the prosecution does cross, and then they do rebuttal, and then they do redirect, and then the prosecutors will now can now do recross, etc. So it's all switched over. Let's see. Hoffinger continues to walk through Costello's emails to Conan, including an email in which Conan says he could rest easy because he had friends in high places. Costello confirms that definitely refers to Trump. Yes. Now, prosecution is showing a May 15, 2018 email between Costello and his partner about Conan. Our issue is to get Conan on the right page without giving him the appearance that we are following the instructions from Giuliani or the president. In my opinion, this is correct strategy, the email reads. Asked about the email, Costello says no, not to follow instructions, but to get everyone on the same page because Conan had been complaining incessantly that Rudy Giuliani was making statements in the press. Another portion of the email reads, we must reverse the Avenatti effect and restore this to a far more simple investigation of things that, while they may not look good publicly, never are and nevertheless legal. Hoffinger then asked Costello, parroting what he said yesterday on the stand, the email speaks for themselves. Costello responded, sometimes. Hoffinger turns to another email from Robert Costello on June 13, 2018, which we've seen previously. Since you jumped off the phone rather abruptly, I did not get a chance to tell you that my friend has communicated to me that he is meeting with his client this evening And he added that if there was anything you wanted to convey, you should tell me and my friend. We'll bring it up for discussion this evening. Costello says for that email, I was encouraging Cohen, as I just explained to you in my previous answer, to express any complaints, and he had several, so I could bring them out to Giuliani and get them worked out, whatever they were. Hoffinger asked Costello to look at an email. She asked, in this email, aren't you encouraging him not to cooperate? Yes or no? No, Costello says. She showed a June 14, 2018 email the jury has already seen. It is clear to me that you are under the impression that Trump and Giuliani are trying to discredit you and throw you under the bus, to use your phrasing. I think you are wrong because you are believing in the narrative promoted by the left wing media. They want you to believe that they want you to believe what they writing. Dear Lord, many of them are already writing that you are cooperating. The email began. If you really believe you're not being supported probably by your former boss, then you should make your position known. If you really want certain things to happen, you should make that known. Javier pressed Costello, saying you were asked by Bove, did you care about Trump's interests while you were dealing with Cohen? Your answer was not. No, my obligation was to Cohen. Yes, that's correct, Costello said in response to that question. I don't really think that this email here is showing that Costello is encouraging him not to cooperate. He's just telling him that, I mean, look, you could read it that way, and Michael Cohen could have certainly read it that way. But I mean, you couldn't make it definitive that, like, yeah, don't cooperate. He's just saying if you don't feel like you're being supported, you should make your position known. And if you really want certain things to happen, you should make that known. So, that could easily be, interpreted as Costello saying, look, you need to tell me what your position is, and I will and I'll go to Giuliani and let him know. Upon reviewing Costello's record or emails, prosecutors Hoffinger asked Costello if he was upset that Cohen was playing him. Costello said that's the wrong word, and no, I was informed. 2018 email suggested Costello was complaining that Cohen was not working with him. The email reads in part, Jeff, this is a response I received from Michael after sending him a detailed text followed by a voicemail 1 hour later. Turn into CNN and see how they are playing this up. Cohen has to know this yet. He's continued to play us in the present. Is he totally nuts? What should I say to this asshole? He's playing with the most powerful man on the planet. The email says. The email speaks for itself. Does it not, Mr. Costello? Hoffinger asks. Yes, it does, Costello says. You lost control of Cohen, Hoffinger said. Absolutely not, Costello says. Hoffinger continued to press him, asking if he lost control of Cohen when he pled guilty in federal court in 2018. Costello said, I certainly didn't have any control when he pled guilty. Hoffinger is asking Costello if he has animosity towards Cohen. I don't have an animosity. I don't think Cohen is telling the truth, Costello says. Yes or no? Hoffinger follows up. No, Costello says. Costello is also asked about his testimony before House Committee last week and if that was an effort to intimidate Cohen. Intimidate Michael Cohen? Costello repeats back. Yes, that's my question, Hoffinger says. That's ridiculous. No, Costello responds. All right, so that's the end of the cross-examination. It was basically her trying to, paint that Costello was trying to pressure Cohen, for Trump. But, I mean, it could be interpreted that way, absolutely, but it could easily be interpreted as another way. So it's not really a slam dunk. So Hoffinger wrapped up her cross-examination, and Bove is back on the podium. Bove pulled up the August 2018 email to Costello and his partner Citron, in which Cohen said, Please cease contact me, as you do not and have never represented me in this or any other matter. Bova asks Costello, from your perspective, was that true or false? False, Costello says. Bova asked Costello to explain what he meant when he wrote to Conan. He thought they had been played in June 13th, 2018 email. Hoffner objects, but Merchant allows him to explain. Yeah, you can't bring that and be like, oh, so you thought this, and then and then they go and ask him, so what did you think? Instead of saying what you think, I think you thought. Tell me what you think. So Offenheimer tries to object, but then Merchant's like, no, you brought it up. He's gonna be allowed to explain. You know this. Costello says that he was referring to Conan not signing the retainer agreement that his partner Citron had given Conan after their initial meeting. Every time Jeff asked him about the retainer, Michael, did you sign the retainer yet? He gave us an excuse. Bova asked, were you concerned you were representing Conan when he wouldn't sign the retainer agreement? Yeah, sure, Costello says. Now, again, what's bad for Conan is he has a pattern of this behavior. Like with Stormy Daniels, he tried to push off paying her until basically the ultimatum was laid down, and then he scrambled to pay her. Bove is now asking Costello about the back channel email. Bove asks who first used the word back channel. Costello says Rudy Giuliani in response to my telling him we couldn't make this public because that's what Conan said to me. Hoffner a bit earlier asked Costello if he was pushing Conan to retain him because he could provide a back channel to Trump, which Costello denied. Costello said they'd let Trump's inner circle know through a back channel that Costello would represent Conan, but Conan expressed concern, saying, we don't want to go public with this. It would cause a press uproar. Bove confirms, Costello, that the first mention about the back channel was sent in an email the day after Costello told his son he'd be representing Conan, showing him the statement Conan was set to release. In a June 13th, 2018 email that Bove is reviewing, Costello wrote, you have the ability to make that communication when you want to. Whether you exercise that ability is totally up to you. Was that pressuring Conan to do anything? Bove asked. No, not at all. Did you ever pressure Conan to do anything? I did not. Costello says, did you ever have control over Conan? Bove asked. Clearly no, Costello says. All right, so, and then after that, obviously the Crocs examination is ended, and Blanche rests. The defense rests, Blanche says. Defense case lasted just over 2 hours compared to weeks for prosecution. While the prosecution called 20 witnesses to testify, the defense decided to call a paralegal from Blanche's law firm for a brief testimony before calling Conan's former legal advisor, Costello, to rebuff some of Conan's testimony. Despite repeatedly saying he would be willing to testify in his own defense, Trump ultimately did not take the stand. He is charged with 34 counts of false business records to cover up a hush money payment to adult film star Stormy Daniels shortly before the 2016 election. Closing arguments are expected to take place next Tuesday, the day after Memorial Weekend. And then prosecutions have no rebuttal witness, nothing further, Judge Steinglass says. So there we go. That's the end. Everything's done. So now at this point, they're just going to argue over instructions and shit, I think. And again, let me go over this first point, like where Trump's saying he would be willing to testify in his own defense. I'm sure he was willing to testify when he thought the prosecution had a case. But that doesn't look like they do. Like, at the end of it, their case hinges on a known liar who repeatedly lies, who admits that he lies when things are personal to him. And everything. Oh, God, I don't know why I'm so stuffy. Anyways. But yeah, so the prosecution case rests on a known liar who admits he lies when things are personal to him in court, and admits the Trump trial is personal to him. So back when Trump said he would testify, it was when he thought the prosecution had an actual case. If all your case, if you're getting charged with something and the prosecution's entire case really rested on a known liar, would you feel the need to testify? Okay, because like look, like again, like I keep saying, he promised to testify when he thought the prosecution had an actual case. When it turns out they don't, why? Why? Why should he even testify? What do we really testify to? No, we had a retainer agreement. You just didn't have it on paper. It was all he could really say. And like everyone else has already admitted that Trump was busy during the while he's running the White House. His personal aide said that like sometimes he'll sign a check, not even look at it. So it there's not really much that Trump needs to really say. The only thing that may be beneficial to him would be if Trump was on Trump was testifying. Says no, there wasn't. No, we didn't have a signed one, but we had one, an oral agreement. And most of the time, and most of those checks, I didn't know what I was signing. I was too busy doing other shit. Yes, I would, normally micromanage, but micromanaging in a company level is far different than micromanaging on a country plus to trying to keep your business afloat. That's why I didn't do it. Like that's all he would really testify. And there's real no point for Trump to testify. All right. So no rebuttal. Judge is now instructing the jury on timing. He says he expects the nominations will take at least a day, and he prefer not to break them up if possible. There's no way to do this in a cohesive manner this week, Merchant says. He says the best thing is to adjourn now and hear some nations on Tuesday. I've considered all the permutations. At the end of the day, I think that the best thing that we can do is adjourn until next Tuesday. At the time you will hear the subnations from the attorneys, probably Wednesday, I'll ask you to come in, hear jury charge, and then I would expect that you will begin your deliberations, hopefully at some point on Wednesday. Okay, so it might be they'll do deliberations on Wednesday. We may actually get a verdict on Wednesday. So I might do a small thing on Thursday saying, hey, Trump was guilty or Trump was found innocent. Let's see. So it might be tempting to think that now that both sides have rested, you can kind of let up a bit, but in fact, these instructions take a greater significance. Merchant tells the jury of his instructions not to talk about or research the case. He also asks them to think about if they can work late next Tuesday. Since he's not 100% sure, we're going to get both subnations done by 4:30 p.m. ET. So I guess Tuesday is going to be a late start. Costello testified for an hour and 14 minutes. Like, how confident do you have to be that you only bring like one real witness and then rest your case after that one? How confident you have to be? You have to be kind of fucking confident. And yeah, I think they have the right to be that confident. All right. So jury left the room. Thank you. I'll see you next week. He tells the jury as they depart. Merchant says they'll be back at 2:15 to discuss the charging instructions. So these are basically the jury instructions. I'm just gonna. So these are all the people that testified: Pecker, Graff, Farrow, Dr. Robert Browning, Philip Thompson, Keith Davidson, Douglas Dowse, Hope Hicks, Jeff McConney, Deborah Tarasoff, Sally Franklin, Stormy Daniels, Rebecca Machino, Tracy Menzies, Madeline Weiserhout, Daniel Dixon, Jenny Tomalin, Georgia Longstreet, Jaden Jamal Schneider, Michael Conan, Daniel Sitko, and Robert Costello. Those are all the witnesses that testified in this case. And again, none of them actually ended up they're like, people were like, oh, but McConney, he testified how Conan's payments were listed. Okay. He also said that the system was ancient, so you couldn't really customize it. So you kind of were forced to do what you do. So that's the only one that has any weight to it. And then Conan, that's the other one. But again, like all Makani did was just show how they were listed. Okay. And then Conan, all he did was saying, yeah, that's false. Okay. Again, no liar, just saying, yeah, that was false. Who do you believe? All right. No, I guess Trump is still under the gag order. All right, so judge and lawyers for the defense and prosecution are meeting now in the courtroom to work on jury instructions. During the charge conference, the parties will hash out instructions on the law that the judge will eventually read to the jury as he charges them to begin deliberations, which could start next week. The jury is not present for these proceedings. The defense case is arrested its case Tuesday morning, just one day after the prosecution rested its case. Trump is back in the courtroom with a group of supporters behind him, including his son Don Jr. It's unclear how long the charging conference will last. Both is up and they're discussing campaign finance violations. O says the defense wants judge to instruct the jury about the federal election law that will need to that there needs to be a willful violation. Otherwise, it would allow the jury to think about the precedent offense in civil terms, or predicated offense in civil terms. Because Colangelo is arguing about the language regarding federal election law on behalf of prosecution. The plain text of the statute provides election conspiracy occurs when intended results are executed through unlawful means. There's no need to add the word willful. The other crime here is the election law violation, which becomes a crime violation when two or more persons conspire to promote a candidate for election by unlawful means. How is killing bad stories and ramping up positive stories illegal? Judge says falsified business records in the first degree requires that there need to be an intent to defraud that includes the intent to commit another crime. Colangelo says the other crime is the election fraud violation that is created through the alleged conspiracy. He didn't really prove any conspiracy. I mean, he doesn't need to, but still. But the prosecution says the object crime does not need to be complete. There just needs to be intent to commit the underlying crime. You didn't really prove that they intended to commit the crime. Like, you know, if you didn't think it was a crime, is it really intent to commit said crime? I don't know. Both sides are now discussing the language the defense want to include in jury instructions. The defense wants the jury to be told that in 2015 and 2016, there was no limit on a candidate's ability to contribute personal funds to his or her campaign. It has nothing to do with the case and extraneous and would probably be confusing to the jury. Colangelo argues regarding the language on candidates' personal contributions. Urgent says he will not give the jury instructions on the issue. He tells the defense that in closing arguments that if your client had certain wealth, he could have paid for this himself. Judge says he reserves his decision on the willful issue. Defense argued that any violation of campaign finance laws had to be willful and that the word needed to be included in the jury instructions. Prosecution said there's no need to add the word willful. Defense wants the jury to instruction to include the line for the purpose of influence in an election requires proof that activity clearly and unambiguously related to President Trump's campaign. Both says they were seeking to provide this type of content through the testimony of campaign finance expert Brad Smith, had they been allowed, so they're asking Merchant to include it. Colangelo disputes Bove's claim about the phrase is a fact of law. Colangelo says the jury probably needs less, not more, when it comes to the Federal Election Campaign Act terms. I think the jury probably needs less, not more, on FECA instructions, and we think that the term for the purpose of influencing election is a pretty straightforward term that the jury can understand. Says he won't include. Judge says he won't include it, knowing that some of these issues related to FECA are confusing enough for the jury. He says other portion of the instruction will accomplish what Trump's attorneys are looking for with that phrase. Judge now moving on to a request for prosecution to tell jurors that candidate status does not have to be the sole or only motivation for the third party payment, so long as the payment would not have been made but for the candidate status of the candidate for federal office. Merchant is reading part of Trump's team's proposed language that said he sums it up very well. Sums it up very well. If the payment should have been made even in the absence of the candidacy, the payment should not be treated as a contribution. That's actually a good instruction because, for the Stormy Daniels payment, they basically alleged Trump was first concerned about his family. So it's kind of saying that Trump would have made this payment regardless of whether he was candidate for president or not, because it would have hurt his family. So therefore, it's not a contribution because it would have been made regardless of his candidacy. Trump's team wants to include some examples. This is an area that's technical and somewhat confusing. Both argues. Both again says it's something would have asked former federal election commissioner Brad Smith about if they had been allowed to. Merchant is reserving the decision, but said he's inclined to use Trump's last sentence in the line for the prosecution. I'm assuming that means Trump's team. All right, hold on. What's this analysis? No one would be a really big problem for the defense because Costello was a disaster. Okay, I am convinced that it was Trump that insisted he be a witness. I am now convinced that Trump was looking for number one being called by calling him as a witness and ended up stepping in number two. All right, so it normally be a really big problem, but here's the difference. This 1 week is going to work as arrest. Okay. Prosecution and defense are discussing a definition involving legitimate press function, a broad concept of normal tasks such as solicitation letters or seeking new subscribers to a publication. In this case, it's about AMI. Both argues that the defense wants to make clear that the AMI did not publish articles and do things for Google pursuant to an agreement within normal legitimate press functions. Merchant says, why can't we just strike the phrase legitimate press function is a broad concept. I can keep what you have before that and what you have after that. Colangelo says he thinks that some of the other language is unnecessary. Merchant says there's no harm in including that line. Let's see. Merchant is now discussing another language dispute that appears to be related to Cohen's crimes. Defense want a sentence in jury instructions to read participant in a crime. The prosecution wants participant in and was convicted of 2 crimes. Merchant agrees with the defense to tweak it to say participant in crimes, plural, and remove the language about being convicted. They also are debating including accomplice versus culprit in the sentence. You should know going forward for the rest of this conference and beyond where there is standard pattern jury instructions. I don't deviate, Merchant said. Steinglass says the defense suggests a culprit had deviated from standard jury instructions. So judge is now reviewing some instructions jointly submitted by the parties earlier today. In a moment of levity, he says the word ilmosanari can be struck from definitions they propose reading to the jury. Merchant joked that he tried to pronounce it several times but cannot, so spelled it out for the court reporter. He also said it means charitable. Colangelo laughed, said they'd be fine with that. That's hilarious. This is such a hard word to say. I don't want to say it and make myself look like a fool. Now that there's a discussion about how they will instruct the jury on how a person causes a false entry in a business record and what that means. Both objects to prosecutor's language, saying they want to strike the phrase "a person causes a false entry" when Both argues they could be convicted based on someone else causing a false entry and accessorial liability. Based cause, this causer, where, for example, if Weiselberg caused someone to do something and then Trump caused Weiselberg, it doubles up on accessorial liability. Judge agrees with the defense, but then here's prosecutor Colangelo. Colangelo says it's an extremely important concept because Trump lawyers argued in opening that Trump did not deal directly with the business records. Colangelo says Trump could have acted in concert with Weiselberg to cause the false entry. Merchant responds, isn't this already covered in the definition of accomplice liability? Merchant is reserving decision, but says his inclination is to strike the line as Trump team requested. Trump team wants the judge to read an expanded jury instruction on intent and also an instruction on intent to defraud. Judge asked why they needed the intent to defraud charge in addition to intent charge. Both argues there is a significant issue with instructions to the jury that intent to defraud would include defrauding the government and the voting public based on the facts of this case. Burton says the prosecution have to prove there was intent to deprive another. They don't have to prove that it's property or money. They have to prove that it was something. Colangelo says the word they are seeking is the controlled definition of intent to defraud, and given the facts of the case, it's important the jury to be instructed on it. Burton said earlier he was inclined to use a line the prosecutor suggested to explain intent to defraud can extend beyond economic concerns. Both contends that they have to tell the jury what it is, not what it is not. He asked if they included that the judge used the defense language that includes language led another into error or disadvantage. Colangelo says that the language is not part of the official definition in the standard legal definition. Let's see. Judge is addressing language related to intent to conceal or commit another crime. Let's see. Bove is rejecting the language proposed by prosecution that he calls the jury's intention to things that the government does not have to prove. What we perceive here is a risk of burden shifting, Bove says. Merchant says he's not going to rule immediately on Bove's objection. Judge is now moving into the final issue in the section, which he says he has particular concerns about. The section reads, the defendant did so with the intent to defraud. That includes an intent to commit or conceal another crime. Merchant says the defense proposed an additional line. Thus, for the second element, the people must establish beyond a reasonable doubt two separate intents, the intent to defraud and the intent to commit and conceal the aid of another crime. Judge says he's specifically concerned about this language. The defense attorney Bove said he understands that proposed language is not official criminal jury instructions. Colangelo argued the defense version is inconsistent with the text of the statute, and there's nothing in the statute about two separate intents. Burton said he'd keep the standard language on the issue. Let's see. They both move on to another part of submission that judge said he received at 1:05 p.m. today from the parties. As they debate the law and language to use the instructions, the lawyers are often referencing yellow or blue edits on the documents. When they disagree, each can use a color to propose the suite of language that is then submitted to the judge hashing out at the conference. Bove says the defense doesn't think the underlying tax crime predicated should go to the jury, but if it does, it should include the language that says the jury must find prosecutors prove Donald Trump acted willfully with the intent to conceal a tax crime. Colangelo says the alleged gross up agreement and intent to conceal the reimbursement to Michael Cohen that was income clearly goes to the underlying tax crime. Has Trump been charged with the tax crime? The parties are debating over language about the jury's requirement to find the prosecution proved that Donald Trump participated in the alleged conspiracy. Colangelo says the extensive corroboration, for example, that Trump was at Trump Tower meeting with Pecker, that goes to his participation in the conspiracy. Bo says our perspective was discussed in that meeting. What was discussed in that meeting, if you credit the People's Witness, were a series of pretty standard campaign activities that were not a crime and were being practiced by candidates across the country for decades. The defense position is there's nothing criminal at all about what was discussed at the meeting. Judge asked if there's nothing criminal about it, what's the difference between does it make if he's present or not? Colangelo pushed back on this in purview of what to come on closing arguments. Next week, he says that Bove's argument that the 2015 meeting was benign and high-minded discussion about democracy did not match trial record, pointing to the evidence that Pecker just told just a few people about the meeting and told them to keep it secret, and then proceeded to do all the steps of the conspiracy the prosecution argued was unlawful. Arguing for another deviation from standard criminal jury instruction language, defense Bove asked the judge be as specific as possible when describing the statute as they are applied in this case. Nothing noting the importance of the case, and that there's not much a precedent of the way the statutes are being used in this case. Merton says he understands what Bove is saying about the importance of the case, but says you want me to do what you're asking me to do is change the law. I'm not going to do that. All right. So defense and prosecution have moved on to an instruction about tax law. Oh, man. Bove again reiterates that tax crimes should not be permitted to go to jury as one of the underlying crimes Trump sought to conceal when he falsified business records. He goes on to quote Conan's testimony. When asked about Weisselberg's grossing up of the money he was paid, Conan says, I didn't really even think about that. I just wanted to get my money back. Bove said the prosecutors are trying to say Conan was trying to intentionally evade taxes by disguising a reimbursement as income and gross it up to cover his tax obligations. Colangelo argues that the language on tax crimes should be read to the jury because the money that was paid to Conan was grossed up for tax purposes, which was written on notes from Weisselberg and Connie's in evidence. Colangelo notes they were falsely identified corporate payments rather than reimbursements. They were then submitted to the IRS as income through 1099s. Bove says an agreement after the election to do these things is not an agreement to promote Trump's candidacy in 2016. Bove now argues they weren't allowed to ask Conan about his own tax handling of the money, and there's no evidence of Trump or Trump's organization tax handling of the payments. Bove says the defense wants the judge to make clear everything he says to the jury applies to each count at the beginning of the instruction section about the substance of the charges, and he wants the judge to note that charges correlate to what documents separately. There's a break. Judge and the lawyers for prosecution and defense have been hashing out jury instructions, and judge will jury. Oh, okay, that's not important. So there's a break. They're back in session. Judge says he's gone over the issues he wanted to review, and now he's asking the two sides if there's anything else they want to raise. Bove raises an instruction related to bias and that Trump that he says was modified from the Trump org trial. Steinglass says it's not necessary in this case because it was rooted out in voir dire. This was a portion earlier in trial where Steinglass also argues the point of the instructions in the jury trial was to remind the jury that Trump was not a party to the case. Judge says he doesn't normally give this instruction, but he will include the government's modified version. Merchant says he will have the instruction on bias, while also saying the questionnaire had 42 or 43 questions, and voir dire was pretty extensive. Bove argued that he wanted the judge to instruct the jury that hush money is not illegal. Steinglass opposed Bove's request and went on to say that the defense was asking the judge to make their legal argument for them. Shortly after Judge Wade, he said he would not include it because it came out several times in the testimony that hush money is not illegal. Merchant said that he suspected the defense will make that argument during examination, and the prosecution won't dispute that. He said, given an instruction to that effect is taking it too far. I think that takes it to the next level, and actually give an instruction to the bench is taking it too far. I don't think it's necessary. Yeah, he's got a point there. I mean, it came out several times during the during testimony. Hush money is not illegal. Maybe too much to just add that to the instruction. Parties are now talking about an instruction the defense wants to told to the jury as to how they should consider testimony about reactions from outsiders to moments like the Access Hollywood tape. Specifically referencing testimony from Hicks, Bo says they need an curative instruction because evidence of the reaction of others is not coming in for the fact of the matter. It's meant for the impact on Trump's state of mind, which Bo says might not be clear to the jury. Merchant says he thinks about it, but was inclined to side with the prosecution, said there's no prejudicial effect, and the evidence purpose was clear enough to the jury. Bove is now asking a limiting instruction as it is related to Cohen's guilty plea, AMI non-prosecution agreement, and the FEC commission settlement. Judge says he's thinking his limited instructions through the trial were appropriate. Defense proposed an instruction that AMI did not admit to any violations of the law in the agreement. Steinglass called it outrageous. Bove said, I wasn't trying to be outrageous. Bove went on to say that he wanted to make clear that to the jury that the non-prosecution agreement is an evidence to go to Pecker's credibility, not to go to Trump's guilt, like Cohen's guilty plea. That's also an evidence. This is a crucial issue. Bove said, and his concerns that prosecutors will cross the line of discrimination. Steinglass said AMI's non-prosecution agreement and Cohen's guilty plea are also meant to offer context to the facts in the case, not just Pecker and Cohen's credibility. Merchant says the intention is to give substantial the same instruction I gave during the trial relating to AMI's non-prosecution agreement. Bove wants to be able to argue that Cohen testified that Pecker told the agreement was bulletproof, and Cohen communicated that to Trump, and then they should be argued be able to argue it goes to Trump's state of mind and to the fraud. Colangelo says it's a retread of previous arguments the judge had rejected about at the President's Counsel of Defense. Judge agrees. He says he's never heard of presence of counsel, and now the terms has more to involvement of counsel. Merchant tells Bo, sit down. My answer hasn't changed, and honestly, I find it disingenuous to make it at this point. Colangelo says Pecker did not give adequate testimony to show that lawyers adequately vetted the agreement with McDougal because he testified the lawyer who looked at McDougal agreement didn't know all the facts surrounding the situation. I'm telling you, my ruling is the jury will not hear the instruction from the bench, nor are you permitted to make the argument, period. I understand. I just want to complete the record, Bo says. Go ahead. Before moving on, Merge says this argument you've been advancing for many months. This is something you've been trying to get through to the jury for many months. It's not going to happen. Please don't raise it again. Legal team wants to instruct the jury that Conan's phone is being factory reset. Steinglass says he never seen anything like this charge and says that Trump's team wants the jury to be instructed as those their arguments are facts and records. He quibs that he'd prefer the facts not be used in the imaginary record, rather the real one. Bo argues that Conan loaded something onto his phone in 2016 after resetting it, and they don't know what it is. He also points to the apps that delete messages like Signal and Dust to support the Bo's instruction. Judge says Bo effectively questioned the district attorney's technical records custodian who testified about Conan's phone, says Trump is free to argue about it in summations, but he will not instruct the jury about it. But Steinglass cited New York legal precedent asking judge clarify for the jury in curative instructions to combat defense notion there's nothing improper about not having a retainer agreement. Steinglass says it is in fact the law. We don't think that's right, Judge, Bove says in response, pointing to a different New York case law. Bove says he appreciates that Steinglass didn't suggest there were bad intentions on defense parts, but said the prosecutions are trying to weigh on their argument that a written retainer agreement is required between an attorney and a client. Bove cited law, saying the retainer might be required to collect fees from a client when there's dispute over fees, but a retainer is not necessarily required to provide services. I'll read the rules, I'll read the decision, I'll get back to you on that. If he determines there is a requirement for a curative structure, he adds there will have to be a follow-up. This is the government seeking to put weight on their argument. Bove responds in regards to proposed curative instruction. Court adjourns for the day. Okay, so there we go. So next Tuesday, that'll be brought. It'll all come to head. That's what next Tuesday we'll get the instructions, and we'll get some nations, and then we'll get instructions Wednesday, and we could very well have everything set done Wednesday. We very well could. The jury might end up just coming up with a decision then and there. Who knows? I have no idea. But there we go. So tomorrow I will be reacting to panel discussion, debate, or something. Between Lord Chen, Pearly Things, Rachel Wilson, and Isabel Moody and with Timcast. Yeah, so just be on the lookout for that. I'll react to it, and we'll see that. And then Friday we'll do a normal reaction stream that I've normally done. Monday we'll be back to normal. Tuesday back to normal. Wednesday we will be sorry. Tuesday or Wednesday I'll be reviewing what happened Tuesday, and depending on if it takes very long, on Wednesday I might just pop in real quick and maybe do a short show and read the verdict if they come out on a verdict on Wednesday, or otherwise Thursday, Friday will be everything will be back to normal. So it didn't take as long as I thought. I thought this was going to go until June. Fortunately, it did not. So I hope you guys enjoyed the video. Make sure you like and subscribe, give me a follow, and yeah, that's all I got. All right, see you guys later. Peace and peace out.